Welcome to this video series about the Iowa guardianship and conservatorship system for adults. It was developed by the Institute for Guardianship and Conservatorship at the University of Iowa College of Law. This fourth video in the series will give you basic information about the monitoring of conservatorships by the court and the reporting requirements and powers of conservators. Please be aware that a conservatorship must be created and conducted in accordance with legal requirements in the Code of Iowa. The information in this video is for education only. It is not legal advice and is not a substitute for legal advice. You should consult a lawyer licensed in Iowa for legal advice if you have questions about a specific conservatorship case. As Video 3 explains, a conservatorship for an adult is a legal arrangement the court establishes by appointing one person, called the conservator, to make decisions for another person, called the protected person. The conservator makes decisions about the management of the finances and assets of the protected person. Examples of such assets are bank accounts, real estate, and personal property. As Video 3 also explains, Iowa law spells out the requirements to establish a conservatorship for a person who is an adult. First, the court must decide that the person's decision-making capacity is so impaired that the person is unable to make, communicate, or carry out important decisions concerning their financial affairs. Second, the court must decide that appointment of a conservator is in the best interest of the person. Third, the court must base these decisions on clear and convincing evidence. The court's duty does not end after the appointment of a conservator. The court has a continuing duty to regularly monitor conservatorships. Court monitoring is necessary to make sure that conservators fulfill their responsibilities and the protected persons receive needed protection from financial exploitation. The court's main way of fulfilling its monitoring duty is through its review and approval of plans, budgets, and reports from the conservator. Iowa law requires conservators to prepare and file with the court an initial financial management plan when the conservator is appointed, an inventory of assets when the conservator is appointed, an annual report of the past year's transactions and activities, an annual budget for the upcoming year, and a final report when the conservatorship terminates. Within 90 days of appointment, Iowa law requires the conservator to prepare and to file an initial financial management plan for the protected person with the court for its review and approval. This plan requirement has two purposes. One is to make sure the conservator identifies the protected person's needs and then develops a plan for meeting those needs. The other purpose is to enable the court to identify and prevent possible problems with implementation of the plan. Iowa law directs the conservator in deciding the protected person's needs to consider both the protected person's preference, values, and prior directions, and best interests in determining the protected person's needs. The conservator's initial financial management plan must include a proposed budget for the next annual reporting period. This budget must describe the protected person's income and income sources, debts and liabilities, and estimated expenses. This table shows some examples of specific items, if applicable, that should be included in the proposed budget for a particular protected person. The conservator must attach to the initial financial plan a list of the protected person's assets, called an inventory. The conservator should first determine what assets the protected person owns. Examples of specific assets, if applicable, that should be included in the inventory are checking and savings accounts and certificates of deposits, Social Security benefits, retirement assets such as pensions, 401ks, IRAs, and annuities, investments such as stocks, bonds, mutual funds, and exchange-traded funds, personal property such as household goods and vehicles, and real estate. Once the protected person's assets are identified, the fair market value of the assets must be determined and included in the inventory. After the court approves an initial financial management plan with a proposed budget and inventory, Iowa law requires the conservator to prepare and file an annual report for court review and approval. This annual report must describe the protected person's income and receipts for the previous annual reporting period, its debts and liabilities for this period, and its expenditures for this period. The annual report also must explain the conservator's payments in cash or cash withdrawals from a conservatorship bank account or other financial account. In addition, the annual report must include a proposed budget for the next annual reporting period. It is important for the conservator to keep accurate and complete records of income and receipts, debts and liabilities, and expenditures throughout the year. The conservator should use these records in preparing the annual report. The court may ask the conservator for evidence of income and expenditures, such as bank statements and checks. Conservators are not required to have a lawyer to help them prepare and file the initial financial management plan, the inventory, and the annual reports. However, it may be advisable for the conservator to have the assistance of a lawyer or other financial expert depending on the types, number, and complexity of the protected person's assets. For example, such assistance may be advisable if a protected person has multiple stocks and bonds, or if a protected person owns valuable farmland or other real estate. The Iowa Supreme Court has forms for use in preparing and filing required reports available on the Internet. If the conservator does not have a lawyer, the Supreme Court forms must be used for reporting. If the conservator has a lawyer, the Supreme Court forms or some other forms may be used. But whatever forms are used, Iowa law requires all of the same information to be reported to the court, whether or not the conservator has a lawyer. This table shows the links to the Iowa Supreme Court reporting forms. The conservator should file required reports electronically through the judicial branch's Electronic Document Management System, or EDMS. After appointment, conservators may exercise various powers in managing the protected person's assets and finances. Powers are the types of decisions and related actions a conservator is legally authorized to make on behalf of the protected person. The conservator's powers are subject to the court's approval, and the court may limit those powers. The powers that the conservator needs and that the court approves vary in different cases depending on the nature and extent of the protected person's income, debts, and assets. In the initial financial management plan and in subsequent annual reports, the conservator should request the court's approval for whatever powers the conservator believes are necessary to implement the proposed plan and budget for the next reporting period. The court-approved powers of the conservator typically include collecting income due to the protected person. For example, the court usually approves the conservator's collection of Social Security benefits or other retirement benefits for the protected person. Other court-approved powers typically include paying the bills for the protected person's living expenses and support on time and consistent with the budget approved by the court. For example, if the protected person is living at home, the conservator may pay expenses for the mortgage and home insurance, property taxes, utilities, home repairs and upkeep, and in-home care and services for the protected person. But if the protected person is living in a nursing home or other facility, the conservator may pay the facility charges and a personal allowance for the protected person. Still, other powers typically include payment for health care and other care and services that the protected person needs. Additionally, court-approved powers may include investing the protected person's funds, collection of the debts owed to the protected person, payment of the protected person's debts, making of gifts and donations of the protected person's funds and real and personal property, approval of contracts, and selling, rental, and buying of real estate. This concludes the video about court monitoring of conservatorships and the reporting requirements and powers of conservators. We hope the video has been helpful to you. We encourage you to visit the website of the People's Law Library of Iowa for more detailed information and resources on this topic, as well as other topics about conservatorship.